Please invite the next candidate, Vladyslav Oleksandrovych Kukhta.
Доброго дня.
Good afternoon. Now we are considering the issue of compliance of the candidate with the requirement for the position of the judge of the HACC regarding the criteria under Part 4, Article 8 of the Law of Ukraine on the Higher Anti-Corruption Court. We have here representatives of the PCIe, Robert Brookhuizen, the chair of the PCIe, Mary Butler remotely, Norman Armas remotely, and to others. So the Qualification Commission, Михайло Бороніс, Михайло Гоценюк, Роман Кадисюк, Надія Кобецька, Олег Полюш, Ігор Кушнір, Руслан Мельник, Олексій Омельян, Андрій Пасічник, Руслан Сидорович, Сергій Чумак і Галина Шевчук. You have a right to submit recusal, submit applications, comments, and also submit any objections or comments and complain regarding any positions. Do you have any recusals? No, I don't want to submit any recusals. Thank you. The rapporteur on this candidate, we have Mr. Hatzeluk. Thank you. Thank you. Good afternoon. Mr. Kukhta, he is our candidate. So, dear colleagues, Kukhta Vladyslav Oleksandrovych, that's a judge of the Chernihiv District Court of the Chernihiv region. I'm not going to read out general information regarding this competition, as it was already mentioned before. I will start with the following: that with the decision of the High Qualification Commission of the court of the members, in 2025, Mr. Kukhta was allowed for participation in this competition, and the decision of the HQCJ on 4th February 2026, the first results of the qualification exam were approved, and based on those results, he has got 300 points sharp, and he was allowed for this interview. So, Mr. Kukhta has graduated in 2003 from Yaroslav Mudry National Law Academy and has received a degree specialist in law. As far as we know, he has no other academic degrees. In 2003 and 2004, he worked as Chief Specialist of Chernihiv Regional Department of Justice, and since 2004 to 2008, he worked as a judge assistant in the Kurylivsky District Court of Chernihiv Oblast, and as of 25th July 2008, he was appointed as a judge in the main district, and as of 31st March 2010, he was transferred for 5 years for the Chernihiv District Court of the Chernihiv region. He was appointed for this court as a position of a judge without any limitation in time. And I would like to mention that also he was selected 3 times as a chief judge of that court by the general voting, and for those periods are 2019-2022 and from 2022 to 2025, and since 2025 till now. So he now has proficiency in Ukrainian language, has relevant experience, and he has submitted 3 declarations, including integrity declaration, declaration of a person responsible for carrying out duties as a representative of a self-governance authority, and he has submitted documents for preparing to this interview. That's all from my side regarding this candidate. Thank you. Would you like to add anything? Dear candidate, whether everything was mentioned correctly and to full extent? Yes, all is good. Nothing to add. Mr. Robert, over to you.
Thank you, Mr. Chairman. I believe that Gabriella is the rapporteur, your rapporteur of... No, it's Gabriella. Oh, sorry.
Thank you. So, dear Vladyslav Oleksandrovych, we heard your working experience, and you have a lot of experience as a chief judge of the court, yes? Yes. So how you being in this position contributed to corruption-free atmosphere in the court?
So, first of all judges of our court, and our court is a small one. We have only 4 judges there as of now. All of us, that's all, it's how to say, we see each other, we know each other, we know how cases are being considered, how honestly cases are being considered, and any deviations from honest and fair consideration of a case would be obviously visible for our peers. We always discuss issues of an honest, fair consideration of case that's for the public and society to have no issues regarding our court, regarding any potential things that could happen in our court in relation to corruption. I'm not only the chief judge, but also judge speaker. I communicate with journalists in particular. So, if I'm not mistaken, back in 2022 or 2023, also as a judge speaker and as a chief judge, I visited the local radio station where there were local activists also there, and live streaming, I answered questions of local activists and journalists. And after that session, after that live streaming, representatives of society generally expressed their position that they thought that the judicial system, not only our court, but the judicial system, and in relation to the judicial reform, started working better. So they saw some changes for better, for improvement. I also answered questions. Sometimes those questions were quite acute. Those questions I received from journalists, and those journalists who invited me for the radio session. All that was live streamed. It was quite, strange for me. But nevertheless, when I communicate with journalists, I always can give I can ask my colleagues regarding some information required by journalists, regarding consideration of cases or decisions made by my colleagues. And now, it's also related to some popular categories cases.
Thank you. So you indicated that you are working in the small court, yes, and so the parties can foresee what case will go to what judge. Is this the additional risk for corruption?
No, cases are divided automatically by the system. Each judge can see whether any interference happens, whether the automatic division has happened fairly or not. All decisions and all issues related to automatic division of cases is decided by congresses of judges. As a chief judge, and I do no decisions without sharing this information with other judges. So all judges happen to know that automatic division of cases happens and takes place honestly and according to legislation.
Yes, I understand that, but we have in such small courts, we have the periods when there are holidays, somebody may be sick, and you are staying alone. So you always can predict who will solve the case. How can you comment this?
Very rarely it happens that someone is fully alone at our courts and responsible for, this for this part of automatic distribution. As minimum, there's 2 or 3 people. I think that only on the 31st of December, 1st January, it was the only case when was I alone only, and all other people all judges were on annual leave. But on 1st January, there are not so many cases, specifically if that's a challenging case. There are so many cases which are assigned to us that shall be considered by a panel of 3 judges. And if we don't have enough judges for automatic distribution to take place, then if a case is not urgent, we postpone its distribution or its assignment to a judge when other judges return back to work after an annual leave or sick leave, and then automatic distribution happens. So, for such a situation, when a case is assigned to our courts and it's known in advance who it will be assigned to, I can't recall such case in my memory.
So thank you. Now I would like to go to the disciplinary proceedings against you, and they were brought on the ground that you failed to verify the factual circumstances that judges cited as ground for refusal. So can you explain what was the ground or reason for recusal in this situation?
Yes. That was quite a high-profile case. That was about... I will not describe this in detail because it has not been considered yet, and it's being considered now. So we had this case in our proceeding for a couple of months. We requested self-recusal not at once. All the time, the number of defense attorneys increased, and at some stage, the 4th defense attorney joined the case, and as my wife informed me, he was studying in the university together with her. Together with the colleagues, we decided. Our considerations were the following. We decided that this defense attorney took part in the case so that if they disagree with our decision, they would be able to challenge based on the ground that we should have recused ourselves because of him being acquainted with my wife. And that's why we decided, based on this ground, to request self-recusal, because 2 other judges also were friends with my wife, and that's why we decided to request self-recusal based on this ground. Accordingly, the prosecutor was not objecting against this recusal, and the defense party was not objecting either. At the same time, this self-recusal, since the 3 of us requested it, so we were also decided on that in the panel of judges. And since we requested it ourselves, and we satisfied it as well. Once the disciplinary case was considered, I realized, I studied the situation more objectively, and I realized that this self-recusal was sort of like not necessary. So probably because of the fact that this case was a bit complicated, that's why we started thinking sorry, Mr. Vladyslav, a huge request. Please answer the questions in a more concise manner and specifically to the question. Okay, thank you. So we requested self-recusal, we satisfied it, then the security service submitted a complaint. Accordingly, we were brought to disciplinary responsibility. We did not challenge this disciplinary complaint.
Thank you. And do you use the same ground for the recusal in other cases? The same exact ground?
Ні,
Strava.
ні, не
No,
використовую.
no. I did not use it. I do not even remember when else I requested self-recusal.
Okay, thank you. Another question. We can see from the content of this case that it was politically sensitive case, and how you will act in case of success as anti-corruption judge, because there are a lot of politically sensitive cases.
Зрозуміло, я після
I
цієї
understand.
дисциплінарної
After this disciplinary case, I realized what my mistake was, and I decided that regardless of whether it's difficult for me as a judge to resolve the case or no, whether it's easy, anyway, I do not have to choose those options that would be easier. I have to always choose the course of action and the procedural decisions that are required by the law from me. If that's difficult, then I need to act in a difficult manner.
Another question relates to the motivation. You also motivated this ruling, reasoning that media coverage of foreign countries also could cast doubts on judges' impartiality. How do you think could the attention of media affect the judges' work on performance of justice?
На даний час я не думаю, що
Right
увага
now,
ЗМІ
I do not think that the attention of the media to the case can affect my decision making or
мною будуть винесені.
the rulings or decisions that I'm going to adopt. Right now, quite often, because of the fact that we are considering many war-related cases, almost on a weekly basis, we have journalists present with us who are having video recording. We have established contact. We are not prohibiting video recordings. We demonstrate openness to the mass media in our court, but accordingly, no impact on the decision itself is being exerted by them. And their arguments are not being listened to by us. We are only listening to proofs and evidence of the parties.
And could you explain why you decided not to indicate this information about the liability in your declaration in 2021? That was.
Так, як я й
Yes.
пояснював,
As I was explaining,
цей самовідвід був
the self-recusal happened in 2018. The complaint was submitted in 2019, if I'm not mistaken, and I was brought to responsibility in 2020. So accordingly, in 2019, when we were filling in the integrity declaration, I was not yet brought to disciplinary liability, and accordingly, I believe that I did not commit a disciplinary offense. Once I was brought to disciplinary liability in 2020, this disciplinary liability was expunged in December of the same year. So, according to the law, the sanction was expunged, and I was considered as not having any disciplinary sanction. And moreover, while filling in the integrity declaration in 2021 for 2020, I thought that the declaration concerned 2020. So I committed the offense in 2018, and as of 2020, as of the end of 2020, I was considered as not being brought to liability, and that's why I did not mention that. But in other documents at all the competitions, I'm declaring this information.
Thank you. Now I would like to proceed with the cases of drunken drivers, yes, of administrative liability. We can see from the Unified States Register of Court decision that approximately 30 cases was closed by you due to the expiration of the period for imposing administrative penalties. So how can you explain such situation?
That is explained as follows. These are the cases of the previous years when the term for bringing to responsibility was at first 2 and then 3 months. And when these cases were received by the court, the jurisdiction of our court covers the rural area. So only to send the postal notification, the only manner to inform the driver is to send it by post. And the postal service from the city of Chernihiv to a village, if they have a post office, takes about 3 days. And then not all rural residents even have post boxes. And then they received the notification that they had to appear to the post office and to get the summons. Whether they received this notification or no, we did not know that. There were no confirmations that they received the summons. Once it was necessary to have at least 14 days for the summons to be returned to the court, and they were returned to the court because of the failure to receive the notifications. When persons refused to receive the summons, we were considering those cases. And when the person did not receive the notification and the summons, we postponed the court hearing for re-notification of the person being brought to responsibility. So, on the one hand, we had to ensure the right of the person to take part in court hearings. And on the other hand, the court was also obliged to consider the case on time. And, you know, we were always between this hard place and the rock. And that's why the terms expired and the cases were closed. Right now, the term under these cases is 1 year, and we do not have any instances like that in our court anymore.
And maybe you can detail, is it possible to solve such type of cases without participation of perpetrator?
Yes, now we are resolving these cases without the participation of the person brought to the administrative responsibility, but only in those instances when the person knew about the court hearing or where the court has taken all the measures to notify the person of the court hearing and the person is not taking reasonable measures for that, because the person knows that the report has been prepared, but the person is not taking any reasonable measures to find out about the consideration of the case, because we have this information at the website of the court with the dates of court hearing. So now that's like that.
Thank you. You also closed several cases due to the lack of evidence, as the video did not establish intoxication. I have 2 questions here. Do you think the video can prove the intoxication of such a low level? And another one is, does the judge have special knowledge to investigate the video himself or herself?
Accordingly, neither the judge nor the employee of the police do not have any special medical knowledge. But our legislation establishes the following course of actions to inspect for the intoxication. If the police officer has sufficient grounds to believe that the person is intoxicated. So, the legislation does not set out that the police officer can refer any person for this inspection for intoxication, only if there is a sufficient ground to believe that there is intoxication. In every report, the police officers are describing these signs. They are reporting in their report that the driver was driving and there were some signs like trembling of hands, red face, etc. These signs are stipulated in the instruction. They reporting, and when we are studying the video recording as the evidence, then on the recording, sometimes, not often, but as I've mentioned, but sometimes, you can see on the video recording that the police officer just made up these signs. The person is on the video, it looks absolutely sober, absolutely no signs, like no paleness, nothing. The person is looking just like the police officer on the video. But at the same time, sometimes police officers see some signs of drug intoxication. And they, under these circumstances, they referred to under the circumstances under which it is very difficult for the person to undergo such an examination. For example, there was an instance when the vehicle of the person was evacuated. The person was driving a car that was towed by another car. And then police officers, after 10 minutes of communication with this person, stated that this person had signs of drug intoxication and offered to undergo the examination. At the same time, it was there was half an hour remaining until the start of the curfew. And from the location where this person was stopped and to get to the medical facility, it was necessary to drive for about an hour. And accordingly, they were not saying that they would bring this person back to their place of residence. And many people just disagree, do not agree to go to undergo the examination because it's very, not even inconvenient, but there are lots of complexities related to that. But they agree to undergo this examination on the spot. But it's impossible to undergo this examination for drug intoxication on the spot.
Thank you. And the last question from my side is about the increase of monetary assets in 2018, because you declared nothing in 2017, and in 2018 it was declared some amounts of money. How you can explain this?
The matter is that assets, financial savings existed before, but they were below the minimum threshold of 50 subsistence minimums as of the 1st of January. So they were not subject to declaring. I did not declare them, but I had them. They were growing and all the time with every year. And in 2018, these savings reached this threshold amount. So accordingly, they did not appear in the previous year at once, but they were just increased to the amount that exceeded this threshold amount for declaring. And that's why they appeared in my declaration in 2018.
Thank you. That's all from my side.
Any other questions of the members of the PCIe at this moment? No, please, over to you, Mr. Chairman.
Thank you. Colleagues, do you have any questions to the candidate? The co-rapporteur, probably? Colleagues, if you don't mind, I would suggest to dedicate a couple of minutes to the situation with the self-recusal. In particular, Mr. Vladyslav, in your written explanations, you stated that while satisfying this motion on self-recusal, you proceeded based on the fact that there were friendly relationships with the wife of the presiding judge, that is your wife, who started together with an attorney. Given the nature of the proceeding, and objectively, that caused a doubt about the impartiality among external observers. I have a follow-up question. What was the point to mention this character, this nature of this proceeding? In other case, these grounds should not have been the ground for self-recusal? The nature, I meant the name and the nature of the proceeding, the fact that this proceeding was related to a crime that was of international significance. During the court hearing, there were present employees of diplomatic institutions of the neighboring state. Accordingly, there was also attention of mass media to this. And if this was not case under Article 114, but under Article 15, Part 2 of the Criminal Code, would the same fact be the ground for self-recusal? What is the interrelation? I understand. Psychologists stated that this is the assertive bias. When you want to confirm with other facts the decision. I don't know, do you know that better? Yes, I agree that we violated the rules of self-recusal. That's why we did not challenge the decision on bringing us to disciplinary liability. In the decision on liability, it's quite clearly stipulated what we mentioned.
From my side, I don't have any questions regarding this part. If any other colleagues would have questions, yeah. Hello. Mr. Omelyan, Commission member, I would like to return to the issue of the integrity declaration which you filled in. So you were brought to responsibility, and at that moment you mentioned that the period of 1 year has already passed from that moment. So to your opinion, how do you think, in order to have no questions regarding this declaration, would it be more correct and appropriate to mention that, yes, at the moment of filling in that declaration, that period has already passed, but that you were brought to responsibility? Because, the situation is the following. You indeed were brought to administrative liability, but there is no mentioning of this fact either in this declaration or previous one. I agree with you. Yes, I agree that it would be more appropriate to mention this bringing to liability, but at the moment of filling in that declaration, so that disciplinary liability was already expunged. But because de facto, I don't state it, but it could look like that using specific legal manipulations, you didn't reflect this information. And if it had been mentioned there, but with a comment that it was, but not at that moment, so the situation would have been absolutely different. Yes, maybe, but that's what I did and how I did. The only thing that I want to mention that in all competitions which I participated in, I always reflected this information in all the questionnaires that I filled in. So there was no motive for me to conceal this information. And even more to say, that's an open information and High Council of Justice knows about it. Regarding this part, that's all I would like to discuss with the candidate, the issue of minor administrative offenses. So please tell me how you understand this notion of minor offenses. What's it? It's the term of minor offenses. That means that formally the offense was committed, but due to certain circumstances, and maybe the nature of committed offenses or personality of a perpetrator, it had no significant meaning and doesn't create corpus delicti. So it means that the case on administrative offense could be closed in such a case. What could be preconditions for creating a situation when, as you say, formally there is a corpus delicti, but so first of all, it's health status, so health condition. Also, there could be circumstances of, financial nature, family status, such as moms who have many children, or disability status, or the offense itself could have only formal signs of it. For example, if that's an, not heavy, not significant car accident, when damage is not that high, and the damage is inflicted only on the person who actually committed this car accident. But what about formal corpus delicti? If the corpus delicti is formal, then that's more about a person themselves. Okay, then thank you. Again, I don't want to reevaluate your consideration of cases. I don't want to doubt legitimacy of your decisions, but I would like to give just a few examples in this context of your understanding of offenses which considered minor. So it could be considered two different categories of crimes, but let's speak about corruption-related offenses. In one of such cases, person submitted a declaration for 2017 and submitted it on 4th May 2018. So it means they violated this term for submission of declarations for more than a month. And in your motivation, you say that guilt of a person is confirmed, but given the nature or the character of the committed offense, the person, the level of guilt, the financial status, the amount of declared income, the court comes to the conclusion that the offense has a formal nature, has no negative consequences, and in such a way there's no administrative liability because of the minor nature of this offense. In such category of a case, in this category of considerations, what could be negative consequences of failure to declare before the deadline? But you say that such declaration after a month of the deadline didn't lead to any negative consequences. So the consequences of violation of the procedure of declaring, what's the consequences here? So as far as I understand, so we're speaking about the consequences of the offense itself. This offense is related to the corruption, and the consequence is that it violates the procedure itself, which is envisaged by legislation for submitting declarations. That's a consequence. Clear. So are you speaking about this case? Because I remember this case. Yeah, so there was a violation for more than a month. No, I will give you more details. I remember this case. So that was a member of local council parliament. So that was a woman. So she worked as a dishwasher in Kyiv, but she needed to declare herself as a member of village council, village parliament, but she didn't have any access to internet, any mobile phone. She had only 3 children and a small income. So she explained to the court that this declaration was filled in by her husband, who visited sometimes their village. And when he visited the village, she was working at that moment in Kyiv. So she didn't have this moment to come together with him to fill in this declaration. In a month, he visited only her again. She didn't have any opportunity to fill in that declaration. And so these were the circumstances. That's why even the prosecutor asked for, for closing this case because of the minor nature of the offense. So given the fact of her financial condition and having 3 children, and even she didn't want to be that member of local council, but she had that duty. So, okay, thank you. So prosecutor at that case asked for bringing to liability, but use the minimum level of sanction or penalty, considering the circumstances that you described. Okay. In another case, there were 2 times also a member of a local council violated deadline for submitting declarations, and they submitted declaration in October 2018, so in more than half a year, and second time in April 2019 for the year 2018. But again, the court mentioned that given the consideration of the circumstances, the nature of offense, the financial status, and so on, this offense has a formal nature. Again, this person was relieved from responsibility because of this term or the notion of minor offense, even considering that the prosecutor actually in that case asked for bringing them to liability. So yeah, if we compare those 2 cases, when we have only minor offense and when we have no corpus delicti, or the situation when we have 2 cases, 2 actual violations of deadlines. Thank you, I've got your question. Also, so those persons in that case, they didn't know how to use information systems. They didn't know how to use internet. These are local council members of local village parliament, so to say. That's why I decided that that offense was a formal one. If anyone helped them, arrived to them, helped them to fill it in and submit, the situation would have been different and the violation would have been different. Okay, thank you. Thank you so much. I have no questions, all is clear. Then let's continue these offenses which you considered minor. Regarding, so there was regulation on 20th October 2021. The case was on bringing to liability of a person under Article 130, and you also made a decision on relief from liability because of the minor nature of the offense. When the decision was made in October 2021, so at that moment, the amendments to the Code of Administrative Violations had already been made in March the same year, which actually envisaged that this issue, this notion of minor offenses, shall not be applied for offenses committed under Article 130 of the Code of Administrative Offenses. They cannot be considered just minor ones. Thank you. I remember this case very well. We have received a protocol for bringing into administrative liabilities. The person arrived to the court. The person submitted health exam certificate that he had cancer disease. He also looked like a sick person. We also reviewed video recording, and there were also alcohol test results. The result was 0.27. He also objected it and he motivated it with the following, that he was under cancer treatment at that moment, and maybe because of cancer treatment, specifically chemotherapy, it led to such results of the alcohol, because he didn't consume alcohol at that moment. The police officers didn't invite or didn't suggest him to have medical examination, and video recording was not till the end, and that's why I suggested to ask application for the police officers and clarify with them whether they suggested him to go to the hospital and have a medical examination. And he replied to me that he's not going to visit court anymore. I can rule on any decision as I want, because anyway he's going to die. and just giving that circumstance I made a mistake. No, sorry, it's not about a person, but about the fact that at this moment you made a decision which was not envisaged by current legislation. Yes, indeed, I made a decision in violation of the legislation. It was a mistake, and I admit it. At that moment, I made a decision on the same day. I gave him the copy of the regulation, and only later on the same day, I recalled that, yes, indeed, amendments were made to the legislation which further were not allowing to admit such minor offences under Article 130. But I had already no other legal opportunities to change the situation and decisions that I made. One more question to continue to follow up this topic. Given your description of the station explanation, do you follow the changes in legislation? Yes, I follow all changes in legislation, but at that moment, at that situation, I was focused more on deadlines for bringing to liability. Okay, and when you decided on your decision, do you rely only on your memory, or do you open the latest update of or amendment legislation? So have you relied upon your memory? Yes, at that moment I relied upon my memory, but now not. So do you think that is it appropriate for a judge to rely only on their own memory? No, I made a mistake. Thank you. Hello, Mr. Ruslan Sidorovich, I'm the Commission member, and I have some questions to you. They're more related to professional ethics category. So tell me, please, as we looked through your files and your dossier, I noticed quite a picture which is quite not that popular. I mean the following, that in a part of your judge dossier where we have information regarding period of deadlines, violation of deadlines for making decisions, and so on. In all sections, you provide no information at all. And I think that since 2019, you have been a chief judge of a court, yeah? Yes. So can you explain, please, why such information is not
Recording in progress.
The broadcast is back in 3, 2, 1. The broadcast is back and the video recording continues. Yeah, all is good. So maybe question. Yes, please repeat the question again. Thank you. That's me, Ruslan Sidorovich. So maybe you have had now enough time, additional time to think about my question because of this technical problem and problems with power supply. So let's go back to my question. In your judge dossier, there is no information regarding terms for producing court decisions and compliance or violation of terms and deadlines for filling in this information in registers. So this information is important. We ask them to all candidates. Why is it important for an external observer? Just to explain to the audience, it's important and it impacts on further period for potential challenging of the decision. Given the fact that you have been on the administrative position of a chief judge since 2018, and to some extent you impact and you have this opportunity to influence on the how the work is arranged in your court regarding provision of such information. Can you explain why this information is absent in information that you provide the systems?
I cannot explain, frankly speaking. I will come back and then we will clarify with the court operators as to why this information is absent. But I can only answer. The head of the court apparatus provided me information about the previous year regarding judges. The only thing that I can say is that among my judges, I have the highest number of decisions produced untimely in the court. And as to why the information is not transferred, frankly speaking, I will clarify. I will follow up on that. I believe you. I'm only analyzing information that we have in your judicial dossier. Okay. Tell me, please, is it accurate information that you were the chief judge starting from April 3 of 2019 until April the 3rd of 2022? Then you had a break for about a month from May 6th of 2022 until 6th of May of 2025. You were the chief judge, and starting from 2025, you've also been the chief judge. Yes, it's correct. Tell me, please, what happened during the period from May 6th of 2025 until July 16 of 2025. So for 2 months, you were not the chief judge. Another judge of our court was the chief judge, but unfortunately, she retired from the position of the chief judge. She retired from the position of the chief judge. Yes, from the position of the chief judge. On July 15th of last year, while being the chief judge, she retired. So she resigned from the administrative position, or she resigned as a judge from an administrative position, and she remains working as a judge? No, she retired. At the same time, she resigned from the administrative position and she retired as a judge. Yes. Okay, then. Tell me, please, what is your attitude towards the limitation of terms for holding administrative positions in courts? Until 2016, there was a decision of the Council of Justice. It's controversial, but it existed regarding terms for administrative positions. Since the moment of adoption of current version of the law on judiciary and the status of judges, there is a limitation for the term of holding administrative positions. What is your attitude towards this institution, this structure? And of course, there is no formal conflict because you were not a chief judge for 2 months. But there are objective circumstances. The person retired, the staff trusted you again, but is it correct to extend this term for holding the administrative position when another person retired? Just what is your attitude regarding this legal construction? The limitation of the authority of the chief judge to 3 years is positively perceived by me. And I would be very happy if some of my colleagues would become the chief judge of our court. But the situation is just like in other small courts, that not all colleagues want to be the chief judge of the court and to have additional administrative duties. When I had the end of the second consecutive term, I even went on annual leave so that colleagues could discuss that among themselves. Maybe some of them wanted to be the chief judge. Apart from the colleague who became the chief judge and then retired, no one else volunteered. In our court, all the issues are resolved in such a way that I'm not the chief judge who is telling the colleagues what and how to do. I'm just implementing decisions of the meeting of judges. But we are deciding on that collectively. We have only 4 judges left for now. No one else wanted to become the chief judge. And that's why I became the chief judge for the 3rd time. Thank you for your answer. I have no more questions. Thank you. Mihailo, please. Tell me, please, while selecting the colleague for the administrative positions, were you aware of her intention to retire? Frankly speaking, yes, but I hoped that she would at least for a year and a half. But at once, as soon as she had necessary experience for retirement, on the following day, she submitted an application. So then one of the grounds of motivations for selecting her to the position was an attempt to refresh, so to say, the term of period during which you held the administrative position so that you could become a candidate for this position again. No, that was not the motivation, because I could not run for the 3rd term and no one else volunteered And as of the date of her retirement, as of the date when the HCJ adopted the respective decision, you had a meeting of judges in your court and you were selected as the chief judge? Yes, we had the meeting of judges and I was elected again because, again, no one else wanted to run for this position. I understand how it might look, but colleagues know me. And with all of the colleagues, I talked and I encouraged them to become the chief judge, and I would always be willing to help them. And even if now someone wants to become the chief judge, I can resign from this administrative position and I can transfer this honorable but difficult role to them. Okay, thank you. Yes, please. I have one more question in continuation of this matter that we're discussing right now. You said that the role of the chief judge is difficult. You are actually performing administrative functions and not like other chief judges. You are not influencing decisions of other judges. Do you know these facts? No, I did not mean other chief judges of other courts. No, that's not what I meant. Are you raising doubts, other judges in Ukraine? Are you saying that other chief judges are impacting decision-making by their judges? Please voice your position, what you meant. Okay, no. I'm not raising any doubts about the activities of other chief judges, but in the society, there are opinions in particular. I can tell you that based on my work, because people come and sometimes are demanding the meeting with me to complain against other colleagues. And I have to explain that I'm not governing other judges. That's what I meant. Do you have any other questions? Yes, please. Mr. Vladislav, again, about 3 terms. Tell me, please, the first break between the first and second terms, what was the reason for the first break? With a full-scale invasion, the court suspended its activities and we resumed our activities on May the 6th. We had a remote work, but on the 6th of May, we resumed work and we had to elect the chief judge again. Okay, I understand. And no one else wanted to run for this position. Yes, I understand. I was only about the dates. I did not understand at once. Thank you. Sorry. And I suggest to continue discussion of how it looks like. Look, at the website of the court, your powers expired on May the 6th of 2025. At the website of your court, there is a notification dated May 23rd. No, sorry, May 12th. That on the May 23rd, there would be a meeting of judges at which election of the chief judge would be the only item of the agenda. Did the election happen on that date? On May 23rd. That's the only news that I found. I can tell you why we hadn't. Yes, we have the announcement. I mean, the announcement on the election of the new chief judge. You're forecasting my questions? Yes, no, for now, I'm asking only about this. Was your colleagues elected on that date? Yes, on May 23rd. Yes. Next question. Look, when you were elected on the 15th, there is a message. The chief judge was elected. When on May 23rd, Mazhennikova was elected, there is no message no publication at the website of the court. Can we ask why do we have this imbalance, this discrimination? She became the chief judge and she asked the head of the apparatus not to publish that at the website of the court. What about transparency? Openness for people? I was not the chief judge back then. I cannot comment on that. It somehow looks like it happened as it happened. If the chief judge is not a king. Okay, okay. My next question. Tell me, please. On May 23rd, Mazhennikova was elected as the chief judge. On June 20th, she submitted her retirement application in less than a month. Now about perception. It's generally well known, that's a provision of the law, that a judge who is holding an administrative position is getting 10% of extra payment to the basic salary. So the salary is increasing by 10%. It's obvious that she was the chief judge for less than a month, and she got this 10% to her infinite remuneration as a retired judge. Cannot it look, in the opinion of external observers, that it was a collusion in the staff to appoint her for 3 weeks as the chief judge, knowing, and you admitted that, you knew that she was going to retire, and that it was done in order to artificially increase her lifetime remuneration as a retired judge by 10%. I did not know for sure that she was going to retire. And as I have mentioned, I was trying to convince her to work longer. But there was only one candidate, her, and we elected her. She could continue working, but she decided to do that. Do we have any other questions? Yes, please. Look, Mr. Vladislav, let's be honest. I'm looking at the decision of the HCJ. Her experience of working at the position of the judge was over 17 years. 17 years, 28 days, right? And she got additionally the term that that was needed for appointment to the position plus 3 years. So in total, she had 20 years, 28 days. So as of the moment of election, you all knew that in 10 days after election, she would have 20 years and that she would retire. Is it an argument that there was no one else? Let's elect the chief judge for 20 days and she would retire. Obviously, it's normal for you. The previous question was that your term was refreshed. She had 10% of additional payment. Everyone was happy, satisfied. But don't you think that this is like a scheme that she's retiring with a higher remuneration and you became the chief judge for the third term, which is prohibited by the law? It might, of course, look like a scheme, but we thought that she would work longer. That's the only thing that I can say. And my last question is the following. Tell me, please, did you move your belongings from the office of the chief judge? No. Thank you. Let me ask one question, colleagues. We've discussed several aspects related to your professional activities. You admitted a couple of times that in some instances you made mistakes. Like we've just discussed the lot situation, which is at least a ground to ask a question that the commissioner asked you. And I have a following question. In response to the request of the PCIe about the factors, circumstances that could cause concerns about your compliance with the criteria of integrity and professional experience, you said no. Why didn't you mention these facts that we discussed today? And why didn't you answer these questions in advance? I do not believe that. I acted, as I've told you, I always acted honestly and responsibly. I understand that it might look like some scheme, but everything happened as it happened. Indeed, our court is small, and with this position of the chief judge, we have problems with that in small courts. I'm not about that. I'm about your response. You could have described that. You could have mentioned the motivations, the grounds, why it happened like that, and to refute any doubts in advance. Maybe we would not be even discussing that now. I did not think about that, maybe, that it could cause any doubts. Okay, thank you. One last question, if you allow, and please be concise in answering it. According to the law on the High Anti-Corruption Court, the PCIe, in the process of its activities, is supporting the HQCJ, is establishing with professional competence and skills. What are the powers of the High Anti-Corruption Court? That's my question. Consideration of criminal proceedings belonging to the jurisdiction of the High Anti-Corruption Court, consideration of civil cases upon claims on application of special confiscation, upon claims of the Anti-Corruption Prosecutor's Office, and consideration of administrative cases following claims of the Ministry of Justice according to the law on sanctions. Okay, thank you. I have no more questions. Colleagues, do you have any other questions? Dear members of the PCIe, maybe you have some additional questions.
Colleagues, you have no?
Good morning. My name is John O'Sullivan. I'm a retired chief judge from the United States. And we have a joke there that says that chief judge is similar to a superintendent, person in charge of a cemetery. They have a lot of people under them, but nobody is listening. No question.
Nothing further on this side, Mr. Chair.
Добре, дякую. Гаразд. Пане Владиславе,
Okay, thank you. Mr. Vladyslav, now you have an opportunity to address members of the PFAE, HQCJ. Maybe you have some information that we have not discussed that is important in your opinion. Please, the floor is yours. Thank you. I wish to you to make the best choice among the candidates. Okay, thank you. Now I'm announcing the interview over. Thank you for your participation. I'm announcing a technical break now.
Я прошу повідомити, коли припиниться трансляція.
Please let me know when the broadcast is suspended.